I think that's a very tough act to follow, the human drama and everything else that happened during the trial, but we have people who are equal to the task in this case. Jeff Gray, who, as I mentioned, was the progenitor of this whole thing, a keen student of legal history and a federal prosecutor who's also been in private practice and a very experienced trial lawyer, and also a personal participant in some of the events that followed after the Mandel trial, is going to lead our next piece on the fallout from the trial, the legal aftermath, and everything that followed out of the trial. You saw the long timeline, and Jeff is going to lead our participants, our next group of participants, in discussion of that. So please give a big hand for Jeff Gray.
Good afternoon, everyone. Within 2 years of the time that the Mandel case was originally indicted in November of 1975, the case had gone to trial, not once, but twice, and those were not merely multi-week, but multi-month trials. The defendants had ultimately been convicted in the second trial in August of 1977. They were sentenced in October of 1977. As a matter of fact, on October 7th, 1977, exactly 30 years and 5 days ago today. And the district court phase of the criminal case had ended. The appellate and forfeiture proceedings that followed, however, ultimately lasted for a total of 16 and a half more years. And as that length of time suggests, the Mandel case had one of the most remarkable and complex subsequent procedural histories of any criminal case that has ever been litigated. I really find it hard to imagine that its like will ever be seen again. And those appellate proceedings featured more twists and turns and reversals of fortune than an episode of the old silent movie serial, The Perils of Pauline. Here to help us try and make sense of the appellate and subsequent proceedings in the Mandel case are a number of individuals who participated in the case and Professor Abe Dash of the University of Maryland School of Law. First, Al Faginski, who was one of Governor Mandel's attorneys, both in the original two trials in 1976-77 and then on appeal, and then ultimately in the Coram Nobis proceeding in the late 80s as well. We're also going to hear from Professor Abe Dash of the University of Maryland School of Law, who's going to give us some of the background on the mail fraud statute and the McNally decision that changed everything and made possible that startling reversal of fortune in the late 80s. And we're also going to hear from Stuart Berger, who is now a Baltimore City Circuit Court judge, the Honorable Stuart Berger, I should say, and Marty Himmelis, who was back in the late 1980s at the time of the Coram Nobis proceedings, an assistant United States attorney, and has now been for many years a very successful defense lawyer at the Zuckerman firm here in Baltimore. And finally, as you heard from Cy, my name is Jefferson Gray. I was the last person in the United States Attorney's Office to handle the case, and I was involved in handling the Irving Schwartz forfeiture challenge, which ran ultimately from 1989 to 1994 and was the final sort of bell of the Mandel proceedings. Let's begin with Al Faginski. Al, could you start by summarizing the twists and turns of the direct appeal, of which there were a number?
Jeff has given me precious little time to talk about the 16-and-a-half-year process. But let me say that in 6 minutes, I intend to try to give you some perspective. First, the criminal case is simply the tip of the iceberg. There was a civil lawsuit based upon the racetrack interests that brought to the bar of justice all of the same people, with the exception of Ernie Cord and Tubby Schwartz. That case went to the Court of Appeals twice before it was ultimately disposed of. Marvin Mandel was disbarred and then reinstated. This case is a long-term soap opera, someone said. It had great actors, and it was great drama. It, however, is a model for nothing in the annals of justice. Think about it. 2 trials. First trial, the jury was blown up by the fact that a television set was on. The second trial, jury set for over 10 days. There were 2 appeals. The first appeal We won 2-1, and I must digress for a moment on that. Mr. Skolnick tells you that it wasn't a bribery case. I urge you to look at what Judge Butzner in the Fourth Circuit said it was, and I don't have enough time to read it to you. It's in 591 Fed 2nd at 1346 and the pages that follow. The case was reversed because the judge did not give the requested bribery instruction, and bribery was at the very essence of the case. It was reversed not on a technicality, but on a gross error by Judge Taylor. Now let's talk a little bit about Judge Taylor. When Martin Manton was indicted for bribery as a federal judge, Charles Evans Hughes reached down to the state of Maryland and picked the best trial judge in the United States, Calvin Chestnut, to preside. When Warren Burger had that chance and picked Taylor, I assure you, he did not pick the best. Burger's role in this doesn't end with his selection of a judge. Burger's role was played out in two parts. First, on a petition for certiorari, after the case had been affirmed twice by a 3-3 vote and a 4-4 vote at the Fourth Circuit. Well, you might say, well, tie, why did we lose? But we did lose because I won't go into that, but if you're a student of the Supreme Court, they just had a 4-4 tie in a case from New York, and the case never got there. Burger was a chief justice at the time, and they refused to take the case. The very next case that came to the Supreme Court came there 7 years later, when only 2 justices had changed. Justice Burger and Justice Stewart. And who wrote the McNally opinion? And what was the essence of it? McNally was written by a gentleman who's in the Hall of Fame for football, Whizzer White. He was also a very prominent member of the Department of Justice. And he essentially held that the honest services provision of the mail fraud statute was too broad a stretch. Thereafter, we had, now, let's look at the array that voted for reversal in McNally. White, Rehnquist, Brennan, Marshall, Blackmun, Powell, and Scalia. Marshall to Scalia, White writes. 2 dissenters, Stevens and O'Connor. Judge Berger will tell you about the quorum nobis provision, but I want to just say one word of personal preference, and I have gone over by a minute, but this will take less than that. The great drama and the great actors and the great soap opera and the annals of history are wonderful, and it's nice to have them put forth here, and you saw some really terrific lawyers talk before us. It's too bad that Marvin Mandel's legacy is continually shafted by this case, because we shouldn't forget, every time you walk into a district court in the state of Maryland, district court was created by Marvin Mandel's leadership. Every time you sit in a jury that's picked from the voter registration rolls in the state of Maryland, it was created by Marvin Mandel. When you read in the paper that there are judicial nominating commissions sitting and reviewing applicants, remember that it was Marvin Mandel who started that. So if I have one final word to say, the great drama, the great actors are wonderful, but let's not forget the true legacy of Marvin Mandel.
Very good. Thank you, Al, and I think you're almost exactly on top of your 6 minutes, actually, which is probably one of the most impressive pieces of lawyering you've ever done in a long and distinguished career. We're now going to turn to Professor...
I usually take a lot longer than 6 minutes to do it, however.
We're now going to turn to Professor Abe Dash at the University of Maryland School of Law to tell us what was this honest services doctrine that was sort of the core foundation of the Mandel prosecution, and how did the McNally decision in 1987 make it possible for the defendants to ultimately succeed in getting their convictions vacated?
Well, actually, you got to hold on to your seats because I have 6 minutes really to give you a history of mail fraud up to McNally. So starting out, 18 U.S.C. 1341 was passed in 1872. What was its purpose? Well, you read it. The use of the mails for any scheme or artifice to defraud or obtaining money for obtaining money or property, or for obtaining money or property by means of false or fraudulent representation or promises. There were 5 amendments up until 1970 that are really not relevant here. What was the main purpose of the statute? Well, I love this. This is from a congressman who was the sponsor of the bill in 1872. And the sponsor said this is to protect against frauds gotten up in the big cities by thieves and rascals of the big cities to deceive and fleece innocent country people. Our clear intent is to prevent frauds against these people by taking their money and property with the use of the mails. Okay, there's absolutely no question that the purpose of mail fraud was the taking of property and money by some kind of a fraud and using the mails, the Ponzo schemes, et cetera, Now, with some enlargement as to artifice and defraud, the law dealt only with this kind of a concept. And as an anecdotal thing, when I was in the criminal division a long time ago, during the Kennedy and the part of the Johnson administration, we used mail fraud, but it was used only for any kind of device in using the mails to take property and to take money. Now, in the late 1960s or in the 1970s, there was a new concept that started. There's an argument why and where. Many think because of Watergate. The federal government got very involved in political corruption, not only federal, but also in state. And what it began to do is federal prosecutors raised this theory of federal jurisdiction under mail fraud, which is redefining this artifice to defraud. And they redefined it to include intangible rights, or the people's right to honest services of its political leaders, even where the state or the local government has not lost any property or money. Sometimes the indictment would specifically charge a scheme to defraud citizens of their rights to honest and faithful services. Now, this is quite an expansion, obviously, of the mail fraud. This concept spread, the Seventh Circuit picked up on it, and then it spread throughout the country. Every circuit adopted it, or let me put it this way, permitted it in their decision. The decision was purely on the statute, and they simply stated that for the purpose, that for our purposes, 18 U.S.C. 1341 deals only with the use of the mails to defraud someone of property or money. Intangible rights are not in this statute. Now, of course, once McNally came down, this should have stopped, of course, all your basic mail fraud cases that were against corruption or against state officials. And as you all know by now, of course, this led up to the final dismissal of the case against Governor Mandel. And by the way, I can't help but note and talk about real quickly one of our distinguished alumnus, who I regret is not here, but Judge Fred Smolkin was the one who wrote the memorandum of opinion that dismissed the case. And if you have nothing better on a rainy Saturday afternoon, it's worth reading. It's really very well done. Now, Congress, in its wisdom, in 1988, passed a statute. Now, the interesting thing about the statute, they actually were amending one of the drug statutes, but they included in 18 U.S.C. 1346, without any debate, this language. For purposes of this chapter, which is referring to 18 U.S.C. 1341, the term scheme to defraud includes a scheme or artifice to deprive another of the intangible right of honest service. In other words, they overturned the McNally decision. Now, interesting, what does that mean now? Well, we have one Supreme Court case, Cleveland v. U.S., that came down in 2000, where the majority of the court, without getting into the facts, sort of said in an obiter that 1346 has to be sort of taken another look at. You have the one circuit, the Third Circuit, that came out and said that there has to be some boundaries as to what federal government can do in dealing with state officers and state law. You have another circuit, the Second, which actually found that 1341 and the statute 1346 was vague and therefore unconstitutional. We have another circuit, the Ninth, that said there's nothing wrong with the use of 1346 and this intangible right. So we're sort of up in the air. The last thing I would like to note that very few people remember, but during this period, and obviously a little bit before Mandel, the Mandel was in fact indicted at the time, but as a result of the Agnew case and the embarrassment in our state in Maryland with county executives being prosecuted by federal officials, the General Assembly set up a commission called the Tidings Commission. I had the honor of working with that commission in the 70s, and they came down with a report to have a chief state prosecutor so that we would have in the state someone who would be able to prosecute these cases and not depend on the United States Attorney's Office. I won't go into all the details of what happened, but we do have a chief state prosecutor. It's not the one we recommended. It's a lot, doesn't have as much authority as we wanted to give him, but there is now a chief state prosecutor, which has had quite an impact in our system. Why? Because now a state's attorney who runs into a problem of conflict, a problem of, let's say, being a Democrat and prosecuting a Republican or vice versa, he now can turn it over to the chief state prosecutor who is appointed by the governor. In fact, the one who we have has been the original one, and therefore is not conflicted out because of politics. Did I do it in 6 minutes?
Not quite, but we'll. But it was good content. We were glad to hear it all, and those are good points to make.
And I'll open myself up to questions when you're ready.
Right, exactly. Let's now move on to the Coram Nobis proceedings. The McNally decision was handed down, I think, at the very end of the Supreme Court's term in 1987. It took the defendants very little time to get back into court to challenge their convictions once again. And that's what first the Honorable Stuart Berger and then Marty Himmelis, who was the government's attorney, are going to tell us about.
Thank you. I'd just like to give a little context to the time, because Jeff mentioned. McNally was decided on June 24th of 1987. At the time, my friend and former colleague Al Faginski was down at the Fourth Circuit Judicial Conference, and he made 2 phone calls. He first called the governor and said, "We just heard that McNally was decided. Governor, I'm not sure exactly how this is going to help us, but we're going to try." His second call was to me to tell me about the McNally case. At the time, I was a young associate at the venerable law firm of Melnikov, Kaufman, Wiener, Smouse, and Garbus. I was 2.5 years out, and I was to go into the library, as we did back then. I know now it's a little different, but to go into the library and find the vehicle upon which to seek to vacate the convictions of Governor Mandel and his co-defendants. And I didn't know where to start. Obviously, the governor had served the period of incarceration. As you heard, President Reagan commuted the sentence. So the question was, what relief could we seek? Obviously, a habeas would not be appropriate since he wasn't in custody. So I didn't know where to go. So I turned to my friend in the back, Jerry Martin, who was at the Melnikov firm at the time. And I said, "Jerry, is there any vehicle upon which to do this?" And he said, quorum nobis. And I said, what? He said, quorum nobis. We used it when I was in the U.S. Attorney's Office. Go look it up. And so that's what we did. I found a wonderful annotation in ALR third, which I don't know if people use anymore, but if anyone wants to know about quorum nobis, please, I commend you to 38 ALR Fed at 617. And it says it was delivered at common law to relieve litigants from judicial wrongs for which there is no remedy. So I know Katie McDermott used the phrase Hail Mary, which I think was interesting, but in fairness, what we thought in light of McNally, that with all due respect, the governor's actions were not, nor had they ever been, a cognizable crime under the law. So we thought, based on our reading of Whizzer White's majority opinion, that McNally completely and entirely eviscerated the doctrinal foundation upon which the governor was indicted, prosecuted, and convicted. So we sought and we used this vehicle, and the way it works, and it's done very commonplace now, is to file a petition for a writ of quorum nobis, and it emanates from a case in 1954, Morgan versus United States, which goes into the whole chronology of it, but really, Morgan was the case that, according to this wonderful ALR article that we really drafted our petition for a writ of quorum nobis, where the writ of quorum nobis arised like a phoenix, like through the ashes, according to a wonderful opinion that we used, United States versus Travers from the Second Circuit. Judge Friendly, who, as so many people know, was brilliant, and he used Travers in a way in which he applied the doctrine of the writ of quorum nobis in holding that it could be granted in light of a retroactive dispositive change in the law of mail fraud. So what we did was file this petition for writ of quorum nobis in the United States District Court for the District of Maryland. It was assigned to Judge Smalkin, and just to give a real brief timeline, we filed our petition on August 13th of 1987 and requested a hearing. At that time, the government filed its reply after a modest extension of time, and we filed our reply brief on November 9th of 1987. And I remember, after filing our reply brief and delivering it to Judge Smalkin's chambers, going back feeling so proud at what we had done, and I was having lunch at my desk, and I got a call, and it said, Stuart Berg, yes, this is Fred Smalkin. And at the time, I was eating my turkey sandwich, and I choked on it because we had just filed a reply brief. He says, yes, we've got your reply brief, and you have a reference on page 20 of the reply brief to a place in the underlying brief that was presented to the Fourth Circuit Court of Appeals. Do you have a transcript reference for the court? And we had transcript. We had read 27,000 pages of transcript from both proceedings. We did not have a reference to this one place. So I went over to the warehouse where all the transcripts were waiting for us to find the transcript reference. And I did advise Judge Smalkin's staff. And Judge Smalkin granted our petition for writ of quorum nobis the next day in what I would agree was a scholarly 33-page opinion. But he did so without a hearing, which we were obviously very pleased at the relief that was granted. And then after that, obviously, the government took an appeal, and we briefed the issue and presented it to the Fourth Circuit Court of Appeals. And just one last war story, because it really is worth noting. As so many practitioners know, so much of what happens depends on the judge or the panel that one gets. And when we went down to, and it was argued, the Fourth Circuit quorum nobis part was argued in Spartansburg, South Carolina, when the Fourth Circuit did venture out from the halls of Richmond. So we went down, obviously, Marty and Mr. Wilcox for the government, and Arnold Weiner and I, Al Faginski, had a commitment. So we go there at 8:30 in the morning to see who's on the panel, as all good lawyers would do. And we go there and we see that the panel consisted of Judges Widener, of blessed memory, Russell, and Judge Hall. And what was interesting about that is because the first panel that was discussed that voted to vacate the governor's convictions consisted of Judges Widener, Russell, and Butzner. Two of the three judges who initially voted to vacate the convictions on the initial appeal were participants in the panel that Marty and I had in the Fourth Circuit. And I do recall meeting Mr. Wilcox for the first time, walking up to the panel and seeing his face ashen when he saw the panel. But it is a war story, and I think those are interesting because it is a twist of fate, so to speak. But I will tell you one last thing. I had the occasion in preparing this to review the briefs that Marty and we all had done, and it really is, especially for one who doesn't get the opportunity to write as much as we used to, great to see the significant work that was done, the fascinating legal issues, and the way in which they played out through both the Smolkin stage and the Fourth Circuit, and what ultimately was in probably an interesting, ironic twist of fate and ultimate denial of a petition for writ of certiorari after the successful appeal to the Fourth Circuit on the quorum nobis part.
Thank you very much, Judge Berger. Marty Himelis, it was your task in 1987, having inherited what was one of the great landmark triumphs of the Maryland U.S. Attorney's Office, to try and find some way to defend those convictions after the McNally decision was handed down. What was that like for you?
Well, the first thing that I can tell you in terms of what it was like is that you've heard from a lot of distinguished lawyers here today, lawyers who have various distinctions. I have one distinction. I am the only assistant U.S. attorney in the history of this district to lose Mandel. It was, when McNally was decided, first we were all surprised because notwithstanding the history that Professor Dash reviewed, it was the case, as he indicated, that every circuit had adopted honest and faithful services. And McNally came out of nowhere. But it was also clear to us, and when I say to us, it was clear once I became involved, which occurred when Brett Wilcox walked into my office, and I'm not sure whether this was a punishment or a reward, and said and asked me if I wanted to do the Mandel quorum nobis, which we knew was coming. And it was very clear that this was an uphill battle, uphill meaning up a cliff that was 90 degrees. After reviewing, studying the law of quorum nobis, reading all of those pages of the transcript of the trials, I came to the conclusion that there were sound legal arguments. That's not to say that we're under any delusion that we were likely to win, but there were sound legal arguments, and let me see if I can summarize them very quickly in the probably 30 seconds I have remaining. First, McNally did not hold that there was no crime committed here. If you hold McNally next to the series of decisions and the trial transcript in the Mandel case, what McNally holds is that the jury instructions were wrong. The instruction, that's why there was the back and forth between Barney Skolnick and Arnold, I think it was Arnold Wiener, about the lack of an instruction concerning bribery. There's no question on direct appeal, had McNally already been the law, this case would have been reversed. Everybody agreed about that. But the key here was that this was quorum nobis. And as Judge Berger has indicated, quorum nobis is a writ that is a writ of last resort. The Morgan case, which is the seminal Supreme Court decision holding that notwithstanding an earlier revision in the Federal Rules of Criminal Procedure, the writ of error quorum nobis still existed and was available under the All Writs Act, emphasized that it was available only for use in extraordinary circumstances. And of course, on collateral attack, there's always a strong interest in finality. And in the quorum nobis context, that's especially true because first, there's no ongoing deprivation of liberty. And I've been a defense lawyer for 17 years. By no means do I mean to minimize the significance of having been convicted of a felony. But by the same token, it is not the same as a petition that's filed by someone who's in custody, a 2255. And the courts have consistently held that there has to be a very fundamental error, and that's why the distinction is so important between reading McNally as holding that this was not a crime and reading McNally as holding, as I believe it did, that the jury instructions were wrong. McNally didn't hold anything with respect to Mandel, but reading McNally as requiring the conclusion that the jury instructions under the mail fraud statute, as McNally held it had always been intended to mean, the jury instructions were erroneous. And no court had held that quorum nobis was available based on instructional error. And so we started from that premise, and then the question was there evidence of a crime that was presented, and did the jury make findings that were sufficient to establish that a crime was presented? And we argued that it did, that they did, that the jury did make those findings. And there were two theories based on which they made those findings. First, there's been a lot of back and forth about bribery, and whatever the instructions were, there's no way to construe them in any way other than as requiring the jury to find. You couldn't find the governor guilty and his co-defendants without finding that he received these $300,000 to $400,000 in benefits, including interest in 2 real estate entities, that he received them, and that was part of the scheme to defraud. And so our first argument was that as a matter of law, an employee of an employer or a state official who works for the state or a union official or what have you, who receives a bribe, or if you want to call it something else, you can call it something else, but receives a payment that he is not entitled to because it's part of a fraudulent scheme, isn't entitled to those funds, and in fact those funds become the possession of the employer. And so we argued that he held those funds in constructive trust for the state. By the time we got to the Fourth Circuit, 3 other circuits had denied quorum nobis on this basis. Now, there were also circuits who had granted quorum nobis, notwithstanding that argument. But that was our first argument. Our second argument was that there was necessarily a finding of a crime because the benefit to the victims was the racing days. They tripled the racing days at Marlboro. Those are akin to a license. The racing days are what allow them to open the track on 3 times as many days. That obviously was something of very substantial value. And so Judge Berger has described the proceedings before Judge Smalkin, and I might say that unlike the trial proceedings, there were no fireworks. They were gentlemen. We were gentlemen. Not to suggest anyone was not a gentleman at trial, but we had a wonderful relationship, and I think we all respected one another and still do. But in any case, Judge Smalkin, I remember that the governor's counsel requested a week extension to file their reply. We told them we had no opposition. They made that request, and Judge Smalkin said, no, I'll give you 4 days. So they filed in 4 days. I hadn't heard until very recently that Judge Smalkin called Judge Berger, who I then called Stewart, and the decision was, the decision came down the next day. We then appealed, and we knew, again, it was an uphill battle. And what I'll leave you with is the parallels. Judge Berger's indicated one of them, but there are a couple of others, or at least one other. We appealed, and as Judge Berger indicated, the panel that originally reversed the decision included Judges Widener and Russell. And Breck Wilcox was not the only one in the courthouse that day who became very pale, because I remember looking at the panel, and what we knew was a long shot became, we were marching in to slaughter. And when I was arguing the case, Judge Widener, I learned just how expressive his face is, and just how piercing his eyes are, and just how scornful his tone can be. He had very strong feelings about whether the case should ever have been prosecuted. But the one additional irony in terms of the procedural history of this appeal is that we did petition for rehearing and suggested rehearing in bank. And the first time around, as Al Faginski mentioned, there had been, the Fourth Circuit granted the petition for rehearing, and then and that has the effect of vacating the panel opinion. So once they grant rehearing, the Fourth Circuit then sits, as the panel did, reviewing the district court's decision. And they reviewed the district court's decision, and they were equally divided, 3-3 and then 4-4, and that had the effect of leaving intact the district court's decision, and that's why it was an affirmance by an equally divided court. Well, we were very close to being in that position. There were two differences. First, the district court had not ruled our way. But secondly, and more importantly, the Fourth Circuit denied rehearing in bank, but they denied rehearing in bank 5-5. So they were equally divided in denying rehearing. And there was a petition for cert, although petitions for cert, as any of you know who have been in the U.S. Attorney's Office, are handled by the Solicitor General, and the amount of input that they allow us to have is just minuscule. In any case, the one thing that they did tell me is that when we petition for cert, it's granted. This was the exception, and that ended the criminal proceedings. So I don't regret being the only assistant U.S. attorney ever to lose the Mandel case, because it was fascinating to be part of a case of such storied history. And I'll, with that, turn it back to Jeff.
Abe, very quickly.
Yeah, I'm not going to rebut you, it's not that. But to me, part of the confusion that comes out of this is that in these mail fraud cases of corruption, the question isn't that the ones who are convicted are good guys and didn't do anything wrong, or that there wasn't any bribery. But let me just read what the court said was their holding. We read Section 1341 as limited in scope to protection of property rights, not intangible rights. Now, the whole res geste of the mail fraud thing of intangible rights is not the fact that someone took bribery. It's that they had a scheme to defraud citizens of their rights to honest and faithful government. Now, what I'm getting at is that you can say this is a scoundrel, but did they violate the mail fraud statutes because they deprived someone of honest government? Let me give you an example what I mean. It would never be accepted by any federal judge, I'm positive. But if I was a federal prosecutor here in Maryland and someone ran for governor and sent me material in the mail saying, I, as governor, am opposed to any taxes and will never tax, he is elected, and the first thing he does is propose taxes at the General Assembly. Is this a scheme to defraud me in the use of the mail to get my vote? Now, I am making an extreme example, but under this intangible rights, which McNally, I believe, overturned on that basis, they were not, I don't think McNally had anything to do with whether or not there was a bribe or not a bribe. They were simply saying these may be bad guys, but you can get them federally under mail fraud.
Well, Marty Himmels may have a response to that in a moment, but let me see if we can kind of move through some of the rest of this. The McNally case is a very interesting one to read. I mean, it's true that the ultimate decision was 7-2. The coalition of justices who voted in favor of invalidating the honest services interpretation of the mail fraud statute at that time was, to say the least, a broad and diverse one, extending as it did from Marshall and Brennan all the way to Scalia and Rehnquist. But it's an interesting decision. The argument that Justice Stevens advanced that a direct reading of the mail fraud statute, which reads, whoever, having devised or intended to devise any scheme or artifice to defraud, or for obtaining money and property by means of false and fraudulent pretenses, representations, promises, makes certain uses of the mail, has committed a crime. And the statute is phrased in the disjunctive and seems to indicate that a scheme or artifice to defraud can be different from obtaining money or property. And what the majority did in McNally was say, no, they have to be merged. You have to read them together in spite of the fact that they're linked by an or. That's a debatable proposition. It makes it an interesting case. At the end of his decision, Justice White indicated that he said, if we read 1341 as limited in scope to the protection of property rights, if Congress desires to go further, it must speak more clearly than it has. And within about a year after that, Congress spoke quite loudly and established that honest services fraud is actionable under the mail fraud statute, and it's continued to be used ever since, although as Professor Dash notes, the lingering issue out there is an issue of, are there circumstances in which it can be too vague? But to cite a couple of examples, it was used in the Nate Chapman prosecution here a couple of years ago. It was used in the Governor Ryan prosecution in the Seventh Circuit in Illinois just within the last few months, where the Seventh Circuit held that it was not unduly vague there. Quickly, I'm going to try and summarize the very tag end of the Mandel case, which still managed to last 5 years from 1989 to 1994. And you might wonder, what in the world could be left? But in Mandel, there was always another turn around the corner, another twist. And for this, you have to go back to the facts a bit. Back in the early 1970s, when Irv Covens wanted to buy an interest in the Marlboro racetrack, he couldn't do it legally, or at least not without a lawsuit, because he had sold the interest he owned in the Charlestown, West Virginia racetrack, and there was a restrictive covenant in the terms of that sale that barred him from owning a racetrack in Maryland. So he went to his lawyer, a man named Morton Hollander, and said, is there any way I can buy this interest in the Marlboro racetrack? And Hollander said, no, you can't. There was a very close personal friend with whom Irv Covens had a very special relationship by the name of Irving Tubby Schwartz. Tubby, weirdly enough, actually was part of his real name. He had sort of been, I guess you could say, the scion of like a sewing machine business here in Baltimore City, had retired at a pretty early age and begun dividing his time between Florida and Maryland. But he was an extremely close childhood friend of Irv Covens. And in the 6 months of the year that Tubby Schwartz was up here in Maryland, he had a desk at Covens Furniture Store on 1300 West Baltimore Street. And he would just, as he put it in the trial when he testified, his role there was just to kind of hang around. And I think he got paid a salary of something like $200 a week. And not too long after Irv Covens was advised that he couldn't own stock in the Marlboro racetrack, Tubby Schwartz turned up to say to Hollander that he'd like to buy some stock in the Marlboro racetrack. And the prosecutors put together a masterful paper for record at trial showing that there were interest checks and things like that to pay for the loan on the money to buy the stock and everything, where Covens was constantly giving the money to Schwartz, and then Schwartz would use it to pay. And there were alterations in the checkbook, some of which Barney Skolnick and I were looking at earlier this afternoon back in my office, where Tubby Schwartz, when the case became a criminal case, like scratched through where he'd written things like exchange check, apparently with Irv Covens and things of that nature. But the government's theory at trial was that $1 million interest, and it was an extremely lucrative interest in the racetrack, that isn't really owned by its owner of record, Tubby Schwartz. It's owned by Irv Covens. And so under the RICO forfeiture, when Covens was convicted, that chunk of money was forfeited too. But Schwartz could claim that he was an innocent owner. He'd been a witness in the criminal case, not a party, and he had the right to challenge that, just the way someone maybe in a drug case who owns the car or the boat or something like that, but who's not the drug dealer who gets convicted, can come in and say, hey, no, I'm an innocent owner of the car or the boat. And so that's what Tubby Schwartz did. His challenge lasted almost 6.5 years. It was ultimately settled in the spring of 1984 with the government keeping 60% of the value of the stock, $600,000, Schwartz getting the other 40%. When the Coram Nobis petition came along, Irv Covens never wanted to assert a claim to that remaining $600,000 worth of stock. It had always been his position throughout the investigation and the trial that it was not his stock, that it was Tubby Schwartz's. And so it seems that he was never able to be willing to go back on that and make the claim. So the government was left with $600,000 in stock proceeds from a criminal case in which every last single conviction had been vacated. And in 1989, after the Mandel Coram Nobis proceeding was resolved, Tubby Schwartz came in and said, this is impossible. How can this be? Every criminal conviction here has been vacated. Every forfeiture has been thrown out. The government still has $600,000. How can that happen? And the answer of the U.S. attorney at that time, Breck Wilcox, was, You settled. You made a free choice back in 1984 not to take the risks of taking this case to trial. Sometimes things change after a settlement. Sometimes facts change. Sometimes the law changes. And we have to have stability. We have to have predictability. You know, you can't just change a settlement later on because you decide it wasn't such a good idea in light of what happened later. And so that was the core issue that first Judge Young on the district court here and then ultimately the Fourth Circuit had to resolve in the last several years in the Mandel proceedings. And I think it actually is it's an interesting issue, and there was, you know, points to be made on both sides. But Judge Young ruled in the government's favor in a sequence of 3 decisions. That went up to the Fourth Circuit. And once again, the Fourth Circuit reconstituted as best it could the old Mandel panel with Judges Widener and Russell, and then with Judge Hall, who'd been on the Coram Nobis petition in 1988. That case was argued. I drew a much better venue for the oral argument. It was in Charleston in the grand old federal courthouse at the corner of Meeting and Broad Streets down there, which is significant because it was where one of the 4 cases that made up Brown versus Board of Education, the Clarendon County Schools case, was tried by Thurgood Marshall. And a couple of years before I went down there, one of the networks had made a mini-series about the Brown case with Sidney Poitier playing the role of Thurgood Marshall, and they had filmed the sequences relating to the Clarendon County trial in that courtroom. So I had the extraordinary experience for an advocate of getting to go down and argue in a place where not only Thurgood Marshall, but Sidney Poitier had argued in advance of me. For once, Judges Russell and Widener ruled in favor of the government and held that Swartz had settled, he'd made his bargain, and the government could keep that $600,000 in stock proceeds. The question that always troubled me was, okay, I can see how I beat Tubby Schwartz on this because he settled, but what if the Covens estate ever comes back in and asserts a claim? About 2 years later, they in fact did so. And I had spent a couple of years at that point thinking what kind of arguments I would advance when the Covens estate, if they ever did come back in. And their petition came in on a Tuesday, and I thought, crikey, here we go again, back to the races one more time. I'm going to have to request a couple of weeks so I can have a little additional time on this motion to dismiss I'm about to have to draw up. And I hadn't even had a chance to file my request for additional time or even to enter my appearance in the case on Friday, when I received an order that came wafting into my inbox from Judge Frederick Smolkin. Judge Smolkin, as those of you who know him knows, always moved cases with great dispatch and efficiency, hated any old case on anyone's docket with a fierce passion. And I read the first line of the order, and it was, "This ancient criminal case is once again before this court." And that tone kind of indicated where the decision was going to go, and he held that at this point it was way too late for anyone to come in and raise any further challenges to this stock forfeiture. And finally, 18 years and 6 months after the Mandel indictment was returned, Judge Fred Smolkin finally drove a stake through the heart of the Mandel litigation, and it came to an end. We have a couple of minutes maybe for anyone have any questions about the appellate side of the proceedings? Oh, yeah. Okay. Your Honor, we'll go with you first.
Unrelated matter. I didn't hear much about the computation of the sentence by President Reagan. Does anyone know the reasons behind that, and was that contested?
It was not really contested. The Department of Justice had actually recommended to Reagan that he commute the sentence of Mandel and Dale Hess, who was still serving his sentence also at that time. So there was a recommendation that came through from the Department of Justice. It was not something that originated in the White House or anything else. I don't really know what there may have been some health issues. I'm not really sure as to what the reasons were, but it was not really challenged or contested. And then Jim Nolan in the back.
I have a question for Al. I find the whole appellate process to be very disturbing. I'm sure you feel the same way. It's almost as if nobody up the line really cared about whether justice was being done here. But why did it take so long for the Supreme Court to address this issue, knowing it's a simple matter of statutory construction? I just don't get it.
First of all, I am not disheartened by every aspect of the appellate process. There were certain aspects which I embrace. I can't tell, I have no answer for that. But if you think, or if it bothers you, that the appellate process in this case is askew, I ask you to ponder for a moment a legislative process that allows a Supreme Court case to be overridden on a rider to another bill when there is no legislative history made.
Amen.
Now, all of you can sit out there and look down your noses at the Maryland State Legislature, but as the president, former president of the Senate, sitting right down here in the first row, Mr. Steinberg, can tell you, it could never have happened in Maryland because you got the one subject rule. And the Senate of the United States and the House of Representatives of the United States should be ashamed of themselves because they cannot pass legislation today on any subject without it being a rider to an appropriation bill. So if you're worried about the judicial process, just remember that the congressional legislative process stinks to high heaven.
Okay, let's wrap it up there for this panel. We have another interesting panel to go with a lot of very worthy speakers to hear from, so let's move along to that one. Thank you.
Our final panel this afternoon is going to look at something that was touched on a number of times. Something that was touched on a number of times in the first panel, and that's really the political culture in Annapolis and Maryland that gave rise to these prosecutions. And it's a discussion about Annapolis then and now, which will be led by my colleague, Bill Meyer, someone who has been on all sides of this issue as an attorney in private practice, as a federal prosecutor, and as a businessman, and a longtime Maryland resident. And we're happy to have with us some very distinguished guests who can address all of these issues and talk about what, if anything, has changed since the 1970s. And so without further ado, I give you Bill Meyer and our final panel, and we look forward to hearing from them.
Thank you, Cy. We are the final panel of the day. The title of this panel is Annapolis Then and Now. It's interesting that we're going last because when you think about it, this entire Mandel affair started with lobbying. It was all about lobbying and what was criminal or not criminal about that. You've heard several speakers before mention that the Mandel trials marked the end of machine politics in Maryland. We're going to discuss that and what happened then and bring it up to date the present time. And we're very lucky and honored to have quite a distinguished panel for this topic. Some ex-legislators, current lobbyists that have a wealth of experience and knowledge in this field. Let me just briefly introduce them. Barry Raskover is a longtime reporter in Maryland, worked for the Baltimore Sun for many years, covered the Mandel administration. He is now a columnist for the Gazette of Politics and Business, a commentator for WYPR. I'm sure many of us have enjoyed those broadcasts. Lawrence Levitin served in the Maryland General Assembly for 23 years, including 16 years as chairman of the very influential Senate Budget and Taxation Committee. He's currently a partner at Rivkin, Livingston, Levitin, and Silver, and represents lots of clients in a lobbying capacity. Over here on my far right is John Steeroff. John is a very prominent lobbyist. He's an attorney with the firm of Venable. He also worked for the General Assembly for 12 years, including 8 as counsel to the Senate President Mike Miller. He now lobbies on behalf of healthcare organizations, businesses, and trade associations. Sitting next to him is the Honorable Melvin Steinberg, who was elected twice as lieutenant governor of the state, also served 5 terms as in the state Senate, including 3 years as its presiding officer president of the state Senate. He is now of counsel to Rivkin, Livingston, Levitin, and Silver. And finally, Diana Sequela has been a lobbyist for 30 years in Annapolis. She's represented the interests of Common Cause, the AFL-CIO, and for the last 8 years, she's been lobbying on behalf of Maryland State teachers. So we have people that can have covered and been lobbied and done lobbying. So let me begin by asking Diana, who I believe was there at the time in the Mandel era, how have things changed? What happened in the wake of the Mandel trials to change the way lobbying is done here in Maryland?
One thing that I don't mention very often because it doesn't do me much good is to say that I was the executive director of Common Cause Maryland right after this all happened. So when my predecessors passed the first part of the ethics bill that applied to legislative lobbyists, and then when I came in my first year was in '78, and there were some revisions that we passed in '78 and '79, and my first very few women, very, very few women at the time. And when I walked into the Senate, it was Constitutional and Public Law Committee, and one senator, now deceased, was sitting on the right side on the end, eating a brown swagger and onion sandwich and drinking a Bloody Mary. And I thought, what am I doing here? This is abominable. But I stuck it out, and I was too naive to be intimidated. I think my persistence and I just continued to hang around. They couldn't really get rid of me, but I never had access then as I do now. The doors are open now. We can make appointments, we can talk in the hall. It was not appropriate for women, I didn't think, to work with the men because lots of their work was done in the bars. They met after hours and they drank and they partied, and lots of business was conducted, but it wasn't a comfortable place for women to be. So we kind of had to work our way through. I finally earned my stripes when I defeated, I should say, Senator Harry McGurk. Senator McGurk's movie censor board was up for sunset review, and his favorite patronage person was Mary Avera, and it was due to be sunsetted, and I was on the side of sunsetting it, and I sat in the gallery, and when the vote came in and the senators voted with me, I was thrilled, but I just wanted to hide because I got the look from Senator McGurk that would kill. And the rest of that session, he tried to put a sunset amendment on everything. But I've earned my stripes that year, and things have changed greatly since then. Many more grassroots lobbyists, female lobbyists, and I think John can probably fill you in on that, and then you may have something to add too from your
John,
perspective.
can you pick up on that and what the legal framework is now and how that's changed?
I think important, or just as important to kind of follow up on Diane, is just kind of the growth of lobbying and lobbyists, generally, and not unlike most state capitals. I mean, there's just been an explosion of lobbying since the 1970s. In 1979, the first year that the commission administered the state ethics commission, the program, lobbyist expenditures were $2.8 million. In '88, there were 415 lobbyists. Their expenditures were $9 million. 5 years later, in '93, that had gone up to $14 million, only 510 lobbyists. In 2000, 600 lobbyists spent $22 million, and last year, the most recent year that we've calculated, there were 687 lobbyists, and the total expenditures was $37 million in expenditures in the state. And I think that what you've seen in that time, particularly probably beginning in the late '80s, is a consolidation of clients, among lobbyists. In 2000, they calculated that 111 lobbyists had 2 or more clients, but 46 lobbyists had 8 or more employers. Probably today, if you look at the lobbyist list, there's 15 or 20 lobbyists that would have as much as a third of the clients that are before the Maryland General Assembly. I think that we've seen, changes in the law since, 79, particularly two commissions, both in 1998. The Cardin Commission was appointed on the Maryland Public Ethics Law, chaired by, Congressman Ben Cardin, to review and make recommendations of the law as it related specifically to the members of the Maryland General Assembly and its members. In 1999, a number of those provisions were adopted on the solicitation of gifts, limitations on meals and beverages. And then subsequently, in that same session, because the Cardin Commission was not charged to look at lobbyist ethics and legislation with respect to that, the Robertson Commission was named a study commission on lobbyist ethics, due in part to criminal investigations that were going on at the time. The General Assembly had passed two resolutions that year, appointed a commission chaired by Don Robinson, a former member of the House of Delegates and the majority leader of the House. That commission met in both 1999 and the 2000 interims, with a report in 2000, which again passed significant changes, particularly with regard to lobbyist ethics reform, focusing in on lobbyist registration practices, prohibited practices adopted for the first time, what's been referred to as an ethics code, of lobbyists, limited political or certainly monitored political activity of lobbyists, and required the disclosure of contributions by lobbyists to legislators by both themselves and by their employers. Separate reports were required to go to the State Board of Elections, required lobbyists to get training even with respect to ethics, and significantly impacted the enforcement provisions of the ethics law, significantly increasing, for example, misdemeanor penalties for knowing and willful violations of the law went from $1,000 to up to $10,000 per fine. So some significant actions taken by the General Assembly in response to a lot of public activity with regard to allegations of abuse of those laws.
Well, Governor Steinberg and then perhaps Senator Leviton, you both served in the General Assembly during the Mandel era, and now you're on the other side. Share with us your perspectives of how things have changed since then.
Well, first, when I got out of public office, I did lobbying for a year. I couldn't stand it, and I went ahead and became of council and do a little bit of administrative work. But one of the things I think it's important to bring out today, which has not been mentioned, lobbying is an integral part of the legislative process. There's nothing evil or wrong with lobbying. I look at the lobbying aspect analogous to the judicial system. You have the General Assembly sitting before, and today the volume of bills are unbelievable, the volume, and that's why a lot of the increase in the number of lobbyists and the activism that has been in our society has increased tremendously. But most of the bills are technical, or they have a tremendous impact, negative or positive, on a particular segment of the economy. And the reason why you have so many lobbyists, that bills affect a particular industry, be it education, be it commercial with automobile dealers, or with regard to the environment, you have proponents that are lobbyists that are hired by these individuals to present their argument why that bill should be passed or defeated. And the same argument is made, by the other side of that legislation. Lobbyists are no different than lawyers in a judicial case. And a good lawyer may be one side of an issue today and tomorrow on a similar type of case on the other side. It's presenting that side of a case. Legislators are reflective of the community that they're elected from. And in a body as large as the General Assembly, you're going to get some people who are not reputable, some people who are not honest, and some people who take
advantage of their public service. And the overwhelming number of legislators are good, hardworking, honest men and women who try to do a decent job. The biggest change that I have seen in Annapolis is that the relationship between the parties is a tremendous amount of animosity. I certainly believe in a two-party system, and when election time comes around, give it your best and fight. But after you're elected, you're serving the people of the state of Maryland. I think a substantial number of legislators look at it as a job and will do anything to perpetuate themselves in office rather than doing the right thing. And I think that change of Mandel isn't just Mandel. I think society has changed quite a bit. And it's a combination of Nixon and Agnew and the various public officials in Maryland and around the country and people themselves that have changed. But I think today it is a better day because we have more transparency in the legislative process. We have access, which is much more open than before. And I think the most enjoyable years that I spent in the total number of 28 years is being in a position that was able to help many segments of our society by virtue of the position we held.
Thank you, Governor. Senator?
Yeah, let me add, it's funny, I was sitting here today and my eyes were really opened as well. I had not paid as much attention, I guess, as I should of the Mandel case, but I come from Montgomery County as opposed to Baltimore. And in Montgomery County, you have 2 nuclear-free zones. You have one county will pass a bill outlawing Santa Claus. But you don't, what's happened, I guess what happened in those days, you just didn't see in my part of the world, in Montgomery County. As far as I can see, there was no really impact on the legislature from the Mandel event. Marvin Mandel was an excellent governor. He probably was one of the best governors in basically how to deal with the legislature, how to work the legislature. It was excellent. One of the things that happened, I guess, was changing the financial disclosure law because they required the disclosure of property holdings, real property, partnerships and stuff, and things like that. So that was a positive thing that came as a result of that. The ethics laws that have been talked about by John Steeroff and Diane and Mickey, they happened a lot later, and that they were basically as a result of relationships between legislators and lobbyists, and steps that were taken that they felt needed to be corrected, but they haven't all been good. Let me give you an example. One of the things that you can't do anymore in Maryland is you can't take a legislator out for a dinner, individual, or a cup of coffee, or really anything. There's a zero tolerance for that. And that was a healthy thing in the past, to be able to go out with a few legislators and sit down and discuss complex issues. Now you have to take basically a whole committee or a whole delegation. Now when you do that, you go to a restaurant, you spend maybe $4,000, $3,000 to entertain. Now that's good for a big firm like ours where we can afford to do that, but if you're trying to break in the lobbying game, you can't do that. You can't afford to do that. So I think that's one of the things that, that's just not healthy. The camaraderie has changed a lot. When I first got down to Annapolis in the 70s, there was a lot of camaraderie between legislators and lobbyists, and people were talking to one another, and that's basically changed. What?
And reporters.
And reporters. Yeah, absolutely. I was a legislator. I used to have a party every year, once a year, where the lobbyists would come as my guest. So things like that have changed. It has not all been healthy. The other thing is, when you look at the makeup of the legislators today versus the early 70s or even before that, you had various legislators representing different things. You had farmers, you had pharmacists, you had doctors, you had lawyers. So they were able among themselves to discuss issues that came before them. Now you're getting more professional lobbyists, more professional legislators, sort of full-time, and they don't bring all this expertise to them. So they can use the outside help from lobbyists that know the industries that they're representing, and you don't really see as much of that today as you should. So yes, there have been some benefits as a result of the Marvin Mandel case and other cases of that type, but they may have gone too far. And the last thing I want to say is, a lot of times the legislators don't understand what they've passed. And they ask you to do things that you can't do. And then they get upset when you say, well, listen, you all passed a law that says I can't do that. And they don't understand that. So that happens a lot. They pass things and they don't realize what they've passed, and then they want to figure out a way to get around it. So that's not healthy as well. Thank you.
Barry, you've heard these comments about transparency, changes for good or bad. From your perspective, have things changed for the better, or are people figuring out different ways to game the system?
As I look back, the Mandel episode really began the first day that I was covering a General Assembly session. I walked in, and basically a few weeks earlier I had been told that the guy who had been handling state government and politics had gotten into a fight with the city editor and had been banished to Siberia, and that I was going to Annapolis in 2 weeks and was going to cover the budget and the state Senate and most of the Senate committees. And I knew enough to get to Annapolis, and that was about it. So the first day of the legislative session in '72, I walk into the chamber, and first order of business is the vetoes. And I didn't have a clue. I thought that this was the General Assembly standing up to the governor courageously and overriding his veto. Fortunately, the bureau chief then was a guy named Bentley Orrick, who knew better and immediately saw what was happening when he looked around and there were no Mandel lobbyists to be seen anywhere. They just had vanished. I started writing the story, and Orrick took one look and said, let me try my hand at this lead. And his lead was the governor had all but publicly acquiesced to the override of his vetoed bills, which was right on point. So it was a real education for me in a hurry. And I learned in a hurry. And it was very interesting back then because the relationships were a lot closer. And one of the sad things is that today you have to build your relationships as a lobbyist, let's say, in almost an arm's length way. You can't get to know the people down in Annapolis as well as you could previously in an informal manner. It's a lot more difficult being a lobbyist today, as I observe it. And it's a shame because, for whatever the reasons, the Maryland General Assembly has never demanded that they be given the tools to do their job. So you have virtually no staff for individual lawmakers. Compared with Congress, it's a travesty. These guys are almost at the mercy of lobbyists. They depend on lobbyists to get their information. And unfortunately, not enough of them take the time to do their own homework. So they're even more reliant upon lobbyists on both sides of an issue. One of the other things that has changed dramatically is the way news is reported. And unfortunately, I think something happened as a result of Agnew, Nixon, Watergate, and then Mandel, that every journalist coming out of journalism school wants to be an investigative reporter, because all politicians, all elected officials are obviously corrupt. All government is corrupt, and I want to get to the bottom of this. And there was an explosion of kids wanting to go to journalism schools and wanting to be investigators, not necessarily, as I knew it, journalists. And consequently, you arrive today at a point where you have a lot of money and resources being spent by major newspapers, such as the Baltimore Sun, on investigative journalism. And they will send reporters to Arkansas to look into the scandals in the chicken processing farms in Arkansas. But they won't spend the resources to cover the Maryland General Assembly properly. Back in '72, my first year, we had 4 full-time experienced reporters at the General Assembly for all 90 days, living down there. We literally moved into the Maryland Inn and then the Hilton later on. And we would commute on weekends, but we would be there full-time, and most legislators were there full-time. Not a lot of them were commuters. Today, virtually all are commuters except the ones who really have long distances to go. So it's unfortunate, but the routine stuff that happens in our state legislature just doesn't get covered. It used to be that when you picked up the newspaper in the morning during a legislative session, you would have several pages of agate type of what's known as the legislative routine. Everything that happened was chronicled, and you could follow it. And particularly toward the end of the legislative session, this was really important. But you could read in the paper details on every bill, what was happening. That's gone. No more. You may get 1 or 2, maybe 3 stories on a daily basis out of the General Assembly, and most committee work is never even covered, which is really unfortunate. One final thing I wanted to say, and that is the Mandel case, as interesting as it is, was really not about lobbying. This is almost a separate discussion. This was about doing favors for friends in a way that may or may not have been legal. And one of the areas of reform that grew out of this, which we have not discussed, was in the procurement area of contracts in state government. And there were major reforms there, but what's happened is that companies have found other ways to game the system, to try to gain an advantage. You have areas that are probably ripe for investigation as a result of these so-called reforms. So in a lot of ways, the more things change, the more they stay the same. It just looks a lot different today than it did 30 years ago.
We're running a little behind schedule, but I did want to ask if any of the members of the panel had any reaction to what Senator Leviton or Barry had to say. Governor?
Before this program terminates, I would just like to make 2 points that perhaps many of you know, but if you don't know, you should know. A governor only vetoes a bill upon an opinion, usually an opinion by Attorney General's office or an independent legal opinion. The bill that Governor Mandel vetoed was based upon a legal opinion of the late Judge Sherbo. That's number one. It wasn't just an automatic veto where the governor vetoes a bill, and the legislature gets a copy of the opinion. The second point that I wanted to bring out was the fact that most bills are automatic, most vetoes are automatically sustained because the majority of vetoes are based upon duplicate bills. Either House and the Senate pass the same bill, and consequently the governor takes the one bill and then vetoes the other. So the numbers really distort the actual importance or import of vetoes. And last but not least, the bill was overridden very fast because it was a good bill for the state of Maryland. Having the extra racing days and later transferred and closing down the half-a-mile tracks to mile tracks brought in a tremendous amount of revenue to the state of Maryland. The half-a-mile tracks were all dying. At one time, Maryland racing, the whole racing industry has changed tremendously in the last 75 years. But we had a number of half-a-mile tracks, and Marlboro was a half-a-mile track, and it was to the best interest of the state of Maryland to get these days to the mile tracks of Bowie, Pimlico, and Laurel. So it was a good bill. In fact, most of my colleagues who vote, and I voted to override the veto, nobody ever spoke to me because the bill was a good bill. In fact, a gentleman who later became a U.S. attorney and who was part of a coalition that we had down in Annapolis and Baltimore County, Jer Finney, and Jack Bishop from the Court of Special Appeals, we all voted to override it. It was a good bill for the state of Maryland.
Any other comments?
Let me just add one other comment about the Maryland legislature today, and it really it's getting to look more and more like Congress, and that's unfortunate. The middle is sort of disappearing. You go to the left, you go to the right. In 1992, for instance, we were in a situation like we are today. We had a budget crisis, and there was a compromise. Couldn't solve it in the 90 days. We went in extended session, and the two votes that we needed to pass the legislation, pass the tax increase, came from two Republicans, Howard Dennis and Jack Cade. And some Democrats wouldn't vote for it because they were more to the left, wouldn't vote for sales tax. But the problem is you need to get to that middle again, and unfortunately that's not happening. And I think that's a shame, and the more it looks like Congress, that's a shame.
Sounds like a lot of nostalgia for the good old days. Questions? Yes, sir.
Yes, this is a question for Barry Westover, is it? I'm from Anne Arundel County, and I had a case involving the next door marina and the corrupt influence that pursued in questioning the case through the Department Office, through the Board of Appeals, through the Circuit Court, and through Maryland's Court of Special Appeals. Well, I had, in your journalism mode there, I had written a number of letters to the Capital newspaper. And if you know the Capital newspaper, it is the only local newspaper. Not only that, they have certain weekly newspapers like South County and Annapolis and Crofton and so on. And it's all controlled by the office in Capital Newspaper there in Annapolis. So the editor there, a guy named Mark Hart, he put an editor policy. He will edit every letter that comes there and make a decision whether to okay or not. And he would just, everything that's said is disallowed. The only kind of thing that criticizes the legislature there would be some case that was decided and it failed to approve. So they might put it in the paper. But this is something, a case that is underneath the radar, so to speak. That went through the Court of Special Appeals, and my lawyer failed me.
Sir, is there a question for Barry?
Yes. How do I get past this? Any way that I can get past it, because the Washington Post as well as the Boston Sun, there are contingencies in Annapolis would not accept anything on this case at all.
Yeah, this is one of the problems of disappearing newspapers. And it's also a problem that there's a limited amount of space in newspapers for letters, and the policies of editorial page editors varies from paper to paper. And the Capitol in particular, as you know, the Merrill family has a particular ideological bent, and oftentimes if you're not on the same wavelength, then your letter isn't going to get published. All I can suggest is you're going to have to reformulate your letter in a number of different ways until you finally find one that's one formula that works for this particular newspaper, because as you said, they're the only game in town.
Barry is an independent communications consultant, and I'm sure he would be happy to work with you on that project. Yes, Si.
I have a question. We've been talking about the short length of the legislative session and the fact that there is virtually no staff. I mean, doesn't it seem to you all that Maryland, which is now a large, wealthy, diverse state, that it ought to have full-time legislators and give them enough staff that they can understand the legislature?
I don't think you want to see that. I don't think that would be healthy. I think you can get done in a 90-day session what you need. And there is, Barry's right, that, well, the senators do have full-time secretaries and better staff than the House does. But at the same time, the Department of Fiscal Services and Legislative Reference does provide pretty good backup information that you can use from time to time. So I think a full-time legislature would not be healthy.
And while they don't meet in legislative session full-time, I mean, today particularly, legislative committees meet every week, usually Tuesdays and Wednesdays every week. There are committees hearings going on. They're going on site visits constantly. So there's a lot more legislative activity, and I mean, I think that a lot of the legislators would suggest that they really are a full-time legislature, you know, now compared to past years.
Diana?
I would disagree with whomever was talking about more staff. I don't want to deal with staff. These are people that are locally elected, and the staff people are not the people that can give me a yes or a no. I want to talk to the person who can give me a yes or a no, and I want my members to see those people. My members, we have about 68,000 members in Maryland. They vote for those people, and they should know what they're doing, and I don't like personally dealing with staff, nice people, but they can't give me the answer that I need, and they can't give me the vote. This isn't Congress. These are people from their very own communities, and I think they need to be held accountable and talk with and work with their communities.
Yeah,
Governor, I'm sorry.
One thing, that's the main problem with if you ever go to term limits, you find that staff really runs the show because they're there permanently, and that's a mistake.
Yeah.
It would be a mistake to be a full-time legislature. You want a people's legislature. You want legislators that experience the problems their community experiences. There's sufficient staff down there with legislative reference, fiscal services. A lot of legislators don't avail themselves of the services. You have the Attorney General's office that will help you. So there's plenty of time. I think what we need is a restructure of the legislative session. I think it's a crime when people come down to testify before a committee, wait around all day, and then before they have an opportunity to testify, they adjourn, and then the people from Western Maryland or Eastern Shore are really stuck. I think there should be a period of time of filing bills, a period of time of hearing bills, and a period of time of voting for bills, and you can restructure it. The basis of the General Assembly, because it was an agricultural society, so you had it during the winter months when the crops weren't needed to be attended to. I mean, we've upgraded everything else. We've gone to computers down in Annapolis. I think we should have an efficiency study to restructure the legislative session.
Two more questions. Lee?
To follow up on something that Harry said, and I think you honed in, I was sort of curious why you were talking about lobbyists when the Mandel case was about a strong chief executive governor using his public position for the benefit of his private friends. Put aside the other side of the benefits that he got, has that really changed? I mean, with the exception of the Hughes administration, isn't that the way business is still done in Annapolis? Every governor has identifiable close friends and associates who have access. Get things done.
Well, Maryland has a very strong, probably one of the strongest executive systems in the country. And, but you see frankly, I've seen very little problems in terms of abuse by the executive, or abuse by the legislature. In the 24 years I was there, I couldn't really, couldn't say how many times, or I couldn't notice that there were attempted bribes and payoffs.
I'm just talking about pure influence.
Well,
I'm in office, these are my buddies, they do well when I'm here, when I'm gone, the next set of guys do well.
We are a society of special, Lee, we're a society of special interest. If I came from a rural area and voted against the farmers, I'd be out of office after one term. I think what we have to understand is that, that every administration, since Agnew, I came in with Agnew, and then after we then left with Schaefer and myself. But you reward your friends. The key is the quid pro quo. I mean, you should have a matter of integrity, some honesty, transparency. It is one thing of accepting a meal, and something else is accepting a gold watch. I mean, you have to use discretion and honesty. You can't legislate honesty. The crooks are the crooks, and a crook by any other name is a crook. And it hurts all the legislators. And the thing is, we have to be more open and candid with ourselves. There are reporters who do not report honestly. You know that.
I'm shocked to hear that.
Yeah, shocked to hear that. And, the problem is honesty, and integrity is integrity. And I keep waving back and forth on limitations of terms, because the people should make that determination. We are a free society, but we've become so apathetic, and we don't get involved, and we don't work for certain people, that then you need an artificial means that if you're within 2 terms, then you have to leave. I don't know what the answer is get people more involved, and you'll have a better government.
We have time for one last question. Yes, sir.
Lieutenant Governor Steinberg, turning back to that legislative session where the Mandel veto override occurred, how did he typically deal with vetoes, and what was done, if anything, different with this particular bill?
I can only speak for myself, and I think I represent the majority of legislators down there. You look at the bill that was passed. You look at if the bill was vetoed. You look at the opinion that was written to justify the veto, and you make an honest decision whether you're for it or against it. I don't know any legislator that is intimidated by a governor, unless you want to go on the bench and you're right there and there's something else promised for you. A lot of it is amplified from what the real truth is. You look at the legislation. One of the problems, if you talk about staff, is a lot of legislators take the salary, but they don't do the work. They don't do the research. They vote for bills that they don't even read. That's why when you ask them, what about the impact or implication of that legislation, and they don't know because they didn't read it. And that's a problem. On the statement that Diana mentioned with regard to the censor board, may he rest in peace, he was a great legislator.
Yes, he was.
It wasn't the question of passing or killing that bill or passing that bill on the censor board wasn't based on the merits of censorship, which a lawyer would look at for the constitutional basis. Mary Avera was from his district. The Avera family is a big family. You want those votes, you keep that lady working. That's the name of the game.
Well, I think it's 5 o'clock. We've run a half hour beyond our schedule, so thank you very much to this panel.
Sorry.